This is Trial Transcripts Exposed by Crime in Court with Heather. Raw courtroom reads with my commentary. Let's dive in. Hi, everyone. Welcome back to Crime in Court with Heather. This is Trial Transcripts Exposed. We're reading through the Menendez brothers' retrial of where they're on trial for the homicides of their parents, Kitty and Jose. The first trial ended in a mistrial. This is now their second trial. And it was not on camera. So we're reading through the transcript and we're comparing how it's different. And so far, it's very different in that there's a lot that the judge is changing his rulings on. We're finding out, and it's becoming a battle for the defense to do just about anything in their case in chief right now. So we are going to continue reading through their battle because today we do not have the jury in, so it's going to be just arguments. It's actually going to be a little bit shorter, but it's still just arguments. So we're going to get through that in just a minute. Before we do, I want to thank all of my founding justice insiders. So thank you, Toyota Girl 67, SLB 29488. May the force be with you, 4313. Jessica Weenan 6079, Mrs. Apples 2007, Butler 89833, Brooke JF, Jen P 773, Boom Chickawawa 1, and finally Kendall B 5757. Thank you all so much for being founding Justice Insiders. You too can be a founding Justice Insider if you go and join my YouTube channel at the Justice Insider level, which is the highest tier, the $2.99 tier, and you will become if you join between now and June 30th, you will become a founding Justice Insider. Your names will be read in the beginning of every video, or if it becomes too much, then we'll do rolling credits and something along those lines, but we will definitely get your handle on the screen somehow. So thank you guys again for being here, for your support. Anyone watching, thank you for your support. I appreciate it in any way. All right, so let's get to why we're here. All right, so like I said, there's no jury. We're starting the day Friday, January 5th, 1996. The court says, okay, the defendants are in court. All lawyers are here. The jury is not. One of the jurors has indicated that juror has a family emergency that requires the juror to leave today to take care of a child that's ill. Do counsel wish to be heard as far as releasing the jury for the day until Monday? Ms. Abramson says no. Mr. Gessler says no objection, Your Honor. The court says, okay, the juror also has a medical appointment, which she had told me about, scheduled where she had to leave at 2:30 Monday, which means that we'll have to work through the lunch hour until 2:30 on Monday. Ms. Abramson says, we have two witnesses, very brief witnesses, Your Honor, that are only available now, Monday, because we rescheduled them a couple of times, and that's Virginia Lord and Amanda Greer. The court says, sure, we can schedule them. Ms. Abramson says, we'd like to get them on and off. The court says, all right. Do the parties stipulate that there is no need to further admonish the jurors and that they be deemed admonished and no further admonishment is necessary at this point? So stipulated, says Mr. Gessler. And Ms. Abramson says, yes, Your Honor. Mr. Kahn says, yes, Your Honor. The court says, okay, then let's excuse the jurors for the day. That just meant you don't want me to say again, don't read anything, don't speak to anybody about the case. Those are the admonishments. So they were satisfied that they didn't need it again. Ms. Towery says, Your Honor, did you say we'd work through until 2:30 on Monday? Yes. There's a brief pause. The court says, might as well give some additional information regarding medical appointments for jurors that will affect your schedule. A juror has indicated on January the 18th, a juror has to leave at 3:30 for a medical appointment. That same juror had an appointment this coming Monday where that juror had to leave at 4 o'clock, but we have another juror who has to leave at 2:30 on that day, which we already talked about. Then another juror has a medical appointment where they've been in trial for months now. Can you imagine that? Not being able to make a doctor appointment because you're in trial for like, well, the trial lasted 6 months. We were probably like three months in or so. We're halfway in. Hmm. Yeah, can you imagine that? So everyone's got medical appointments. Then another juror has a medical appointment where that juror has to leave at 4:15 on February the 8th. That's all I know at this point. They have all been instructed to do as best they can to have appointments late in the day and to coordinate among themselves to see if they can coordinate dates as best they can. But most people these days are committed to HMOs that don't give them flexibility that people sometimes used to have in medical appointments. Okay. Ms. Abramson says, I want to verify there are court holidays we understand on January 15th, February 12th, and February 19th. Court says, well, it's posted over there on the by the bailiff's desk, which was a list that I gave to the jury. I don't know if you've seen it, but I don't have that right in front of me. Here, I do. January 15th is Martin Luther King Jr.'s birthday, and February 12th is Lincoln's birthday, and February 19th is President's Day. Those are all legal holidays. Well, how lovely for them that they get all of those days off. Most normal people do not. Maybe you might get a President's Day or something, but not all of those. I've never, it depends what sector you work in, like education, government, obviously would get them, but in the normal working world, I've never had those, so must be nice for them. Ms. Abramson says, right. The court says, okay, yesterday you indicated that you wanted to discuss further the defendant's, Erik Menendez's offer of the co-defendant's testimony for the first trial. Ms. Abramson says, right, yeah, two things. First of all, I just want to indicate to the court that we went back and looked at the colloquies that were held in the previous hearings when the issue of if it started out as the people originally offering to bring out prior testimony of one or both of the defendants through the testimony of Detective Zoller. And the court may recall there were a series of at least three, I think, actual days in which that was discussed. The court says, yeah, I have reviewed the material as well. Ms. Abramson says, and at that time, at the end of those hearings on the issue of the best method, whether to bring out the balance of such prior testimony or to bring out such prior testimony under 356, or whether by offering such testimony as we propose to do, the court has basically stated, I won't say ruled, I'm not sure when things are a formal ruling versus an indication of the court's thinking at that time, that the most appropriate method was to present that was the court interrupts her and says, you can characterize it as a notion if you like. This is he was joking because she called something of a notion of his, and he took great offense to that, and then now he's joking. He teases her like this. It's like a backhanded um pacifist kind of, I don't know what the word is I'm looking for, but it's like it's like he's goading her, but there's like truth to it. Like he doesn't like her, I think, and it kind of comes off that way. And even when he's trying to joke with her and be pleasant with her, I don't think he likes her. Ms. Abramson says no. Sometimes the court has characterized it as, I am not sure. You have used different words to characterize things that weren't formal rulings, but in any event, the court's opinion or in the court's view at this time, I think that's the way the court usually frames it, in my view. The court's view at this time, or at that time, was that the videotape recording prior testimony, the videotape of prior testimony, assuming that it appeared more like a deposition in the sense that the camera only showed the testifying party, Didn't pan away to the other individuals, didn't have any logos on it or anything like that, obviously didn't capture other proceedings in the courtroom, was the most appropriate manner by which to present that evidence. So there was a camera in the courtroom for the first trial. Now, if I understand what the court was saying, the court says, I did say that those remarks are not accepting your wording, but my remarks were at page 26882 and 26883. Miss Abramson says, okay, you're ahead of me on this, Judge. You know the page. The court says, well, I read the material before telling you my views. Ms. Abramson says, right. The thing is, Your Honor, that it seems that based on what the court is saying, or was saying the other day, that before the court should make the decision that there would be these insurmountable and time consuming difficulties if ever getting a tape recording version of the testimony in such a condition that it could be played to the jury, that we should first try to work out those difficulties. The simplest method of doing that, since there is also a transcript of everything that was said, is to require the people who are objecting or claim they are objecting in this huge boilerplate fashion, citing every possible section of the evidence code without any argument or factual basis for their objections to parts of that testimony, to put their objections in writing in the simplest possible way, which is to submit to the court the transcripts of Lyle Menendez's testimony and mark in the margin, if you will. It's the easiest way. What they are objecting to, under what evidence code section to file a pleading if they so choose, indicating that the factual basis of those objections are. Or if they don't want to do that, fine. So she's saying basically take the actual printout of Lyle's transcript, his testimony, and mark in the margins everywhere where you have an objection, but actually give your evidence code objection or whatever it is. Um, and then they can discuss it further. Or if they don't want to do that, fine. Frame the objection the way that they would, as if testimony were occurring in front of them, and we would respond as if we were having a sidebar, if necessary, citing other rules of law. We might even agree to omit, without it ever coming to the court's attention, certain things that they're objecting to based on the prior rulings of this court, and that we couldn't agree to the court. Uh, that we couldn't agree to the court would simply rule on based on the writing, just as the court would rule if the contemporaneous objection were being made during the testimony. And if there were areas after the court ruled that we felt needed a further record, we could take that the few minutes it would take, just as if we were asking to approach, we would ask to approach the bench basically in writing and argue our points about things that we felt were within the scope of the court's ruling and were appropriate at the stage of the proceeding when this testimony, which would be offered, which the court has indicated, and I'm not challenging that part of the court's ruling, would not occur until after the Lyle Menendez defense has rested without calling him if that occurs. So we do have the time to do this stuff. Frankly, my concern is, Your Honor, when the court refuses to view a piece of evidence to decide whether or not it's in the appropriate condition to be submitted to the jury, the court is not exercising discretion. I don't believe a court can exercise discretion in determining that piece of evidence it is to be presented under 352 unless the court has first reviewed that piece of evidence. She's saying you're not using your brain, buddy. You're not doing what you're supposed to be doing. You're supposed to be looking at it and making a decision based on your own knowledge, skills, experience, things of that nature. So I think he might take offense to this, but let's see. He hasn't interrupted her yet. So she's still going. She continues on saying, I recognize that it is burdensome on the court to have to watch 3.5 days worth of tape, but I don't think that that's what's required. I think what's required is to force the people to give the court a way to rule on its objections that is not burdensome, and submitting them in writing on the transcript, I would submit, is that method. If the court were to then rule and we were to edit the tapes to follow the court's ruling, it still doesn't require at that point for the court to look at any tapes, because we then turned over the edited videotapes to the prosecution. It's the litigant's job to object or not object. Then they view the videotapes as edited. I love when she gives her description as to what should happen according to the law. If they believe they hadn't been edited in accordance with the court's ruling, any such segment is all the court would have to see. So I think that we could get to a point without involving, and certainly I don't see how it would involve necessarily court time. It's no different than if we were unable to reach agreed upon transcripts of a larger number of tape recordings on one party or the other wanted to use. And then, in my experience, shifts the burden, unfortunately, to the trier of fact, to the judicial officer to listen to the tapes and decide as the foundational trier of fact, as the 402 trier of fact, what is the accurate translation and what is not. So I believe if we take it in stages, the court would not be burdened, and the court time would not be burdened with the enormous task of having to view all the tape recorded testimony. If there are disputes remaining after this process, then the court could view the tapes. The court could take the tape home or work in the court's office at the court's leisure to view those contested portions, and it need not take any substantial court time. But in all candor, Your Honor, I think at this point we have a record where the court has refused to exercise discretion. And although the court has a very wide discretion, I think it has to have something to decide upon, and that something is not yet ripe to be presented to the court. The court says, well, the people's position is that the court has discretion as to the mode of presentation of former testimony, and it doesn't even have to. It does, says Miss Abramson. The court continues, it doesn't even have to enter it into this sort of editing or post editing to exercise its discretion. It can just do that. Saberson says, I think the exercise of discretion under 352, has to involve the court says it's not a 352 issue. Ms. Abramson says, well, I think the court had acknowledged earlier, and the case authority seems to acknowledge that when you have available to you a piece of evidence that includes all the important components of credibility, such as demeanor and tone of voice and all the rest of that, to simply say you're not going to use that because it's inconvenient when the issue of convenience isn't ripe, I think could be considered an abuse of discretion. I think before the court exercises such discretion, it should know what it's ruling against, basically. Now, to take it one step further, however, we have talked to our technical people, and it is doable that these tapes can be digitized to use the modern lingo in a way and presented by an operator in such a way that just as if the reporter were sitting on the witness stand and read a question and there was an objection to that question, and the reporter was then required to stop. The tape is stopped, and if the court sustains the objection, the operator can automatically go to the next question. When that is played, the tape is stopped, and any objections can be made, no different than if the reporter is testifying. But we can do it with videotape. Now, it is not a difficult process, but it isn't free, and we are suggesting that we can do it, and we will do that if need be, but we would prefer not to have to simply play an edited tape rather than have to put this all on a CD-ROM, which we could do and do it that way. But the basic objection of the court sense that it did not want to rule on all these objections in advance, that the objections should be presented individually and didn't want to get involved in an editing process can be obviated by this technical method, which does the same thing. The people can still make their objections. The answer then can be bumped or jumped over as it would be by a reporter, and we go to the next question. So we are proposing that although we would rather not have to do that, we have the time to do that, and we seek the funds to do that. But we don't want to do that if the court would still say that the videotapes could not be used if there is some other reason besides the reasons the court previously articulated with respect to with having to edit it. The court says, okay, let me hear the people's position. Yes, says Mr. Khan. Counsel indicates that she has the time to edit the tape. I think perhaps what counsel should volunteer to do, since she has the time, is to submit a brief concerning each question and answer that was asked of Lyle Menendez in the first trial, and to explain why that question and answer is relevant in this trial and how it satisfies the requirements of Evidence Code Section 350 and 352. I don't see that just because it is the burden of the people. I don't see that just because the people are objecting to that testimony that we have to we have to submit something in writing concerning every question and answer that we object to in that testimony. Counsel has no problems placing this impossible burden on the people. Doesn't off if the people have the resources. I'm sure you have a whole office of people that can help, paralegals and assistant DAs. I'm sure you have a whole office of people that can help. But these defense attorneys, sometimes it's just them running their firms. Anyways, counsel has no problem placing this impossible burden on the people, doesn't offer to shove the impossible burden upon herself. We are talking about many hundreds of pages here, and there is going to be an argument over an enormous amount of material that was asked of the defendant. The question is, when would this be done? She has every right to put in all of it if she wants to. And then you have a right to object what you want to object to. It doesn't have to be she needs to say why this is relevant. She should be able to put it all in. The question is, when would this be done? We'd have to take weeks off in the trial just to go over the material to prepare such a brief, and the brief should first be prepared by counsel and not the prosecution. So, once again, I think the proposal by counsel in which the tape would be edited following such briefing and argument over every question simply is an unrealistic burden, an unrealistic proposal. I suggest that the way we proceed is that if the transcript is admissible at all, if the testimony of the defendant is admissible at all, it should only be admissible by having the court reporter reading the transcript of the jury. And we should, at that time, argue the relevance issues of such testimony and other evidentiary objections to that testimony. It's the most realistic, the only realistic method of proceeding in this trial. The court says, let me ask you, Mr. Khan, you said if the testimony is admissible at all. What did you mean by that? Mr. Khan says, we still object to the admissibility of the testimony. We search for authority to find some case law which would indicate that the testimony is not admissible. And frankly, we can't find any. I think it's a way of presenting testimony that two defendants can present, where one defendant could not present his own such testimony. There seems to be an avoidance of the rules of evidence by presenting such testimony in that matter. As I stated originally when the issue first arose, it doesn't seem fair to the prosecution that if one defendant could not present his own former testimony, that two defendants can conspire to precisely do that and allow the testimony of one without giving the prosecution an opportunity to cross-examine the defendant at the time that the evidence is now presented before the jury. So once again, if I had some case law to cite to the court, I would. Unfortunately, I don't. We would object that it should not be admissible under the form of an exception to the hearsay rule. The only grounds I can state is it's not truly being offered against the prosecution. It is really being offered in favor of the co-defendant and in favor of the defendant who is presenting it, and is thereby defeating the purpose of the statute. And I don't have any case law to support that position. The court says, all right. What about the defense proposal of digitizing the tape recorded testimony? He says, I think that the problem, once again, is ensuring that this is done properly, and how would that actually be done? We would first of all have to have someone digitize the entire testimony of the defendant. There would have to be some means of reference to the transcript so that we would know when on the tape a particular area corresponds to a location on the transcript, kind of like a timestamp or something, right? And we would have to have an opportunity to review the completed product prior to the time that is presented in court to ensure that questions and answers do indeed correspond between the transcript and the recording. We're talking about an an enormously time consuming process to ensure the accuracy of that material. Ms. Abramson says, I don't understand that objection. This is a contemporaneously made video. They all have transcripts of it. The people have the tapes. They've had them since the first trial. I mean, that is as specious an objection as I have ever heard. The court says, first of all, just an observation. The transcript of the first trial might not be identical to the words of the videotape. Ms. Abramson says, right. The tape might be more accurate because sometimes, reporters are under pressure and there is some. The court says they make mistakes like anybody. Ms. Abramson says, yes, they make mistakes like anybody else, and the tapes, in fact, may be more accurate since they are picking up the actual sound recording, and it's hardly an objection that the tape is more accurate. I would point out two things. So she's saying no transcript because the tape is more accurate. She just got him to admit that the transcript is more accurate. So she used that in her argument, which was pretty good. She goes on to say, I would point out two things, though. It is not our preference to proceed with the digitized version. I don't want to slip up and say the wrong thing there. He goes on to say, but it's not the our point is two things, though. It is not the preference to proceed with the digitized version, although it can be done because it's expensive. That's about the only objection. But it's not our preference. We think it suffers from the same defect that having the reporter just read suffers from when we know exactly what the questions and answers will be, since they're memorialized when there are going to be apparently an enormous number of objections. The notion of why can I say that? The notion of contemporaneously objecting to the material rather than editing in advance will lead to the jury hearing question after question after question that objections are sustained to, and that leads to this repetition of it's sort of like the low signo type of problem. Even though jurors are told that they really should ignore questions, nevertheless, it's a very peculiar proceeding for a jury to hear a whole series of questions when we could all say in advance we know they're not going to be admissible, they're not relevant, the court is going to make such a ruling. So I really don't understand the purpose of doing that in this case when we're talking about material that we all believe, and the court indicated the other day, a fair portion, whether substantial or otherwise, some chunks of it is going to be held irrelevant and the court is going to exclude it. So why don't we just do that in advance? The court says, okay, let me ask you one other question of the defense here, and I'll hear a response by the prosecution. You also indicated what you wanted some preliminary or in limine rulings by the court. Ms. Abramson says yes. The court says, as to the scope of impeachment, Ms. Abramson says, yes, Your Honor, not preliminary, really in limine rulings. The court says, well, in limine rulings are not absolute, they can always be changed. Right, right, says Ms. Abramson. Court says, what is it that you wanted to talk about? Well, what we had indicated the court says, does this have to do with whether or not you would go forward with this offer of evidence? Ms. Abramson says, yes, yes. So that's why I want that decided too. So we can save a lot of time and money and effort. Okay, says the court. Ms. Abramson says, I think the evidence we were talking about was this so-called Tracy Baker issue. That's one area that I know the people feel they should be able to get into. The second is, the court says, well, let's start with that one then. Ms. Abramson says, let's start with that one then. Court says, what is it that you want to say about that? Ms. Abramson says, well, as we have indicated in our pleadings, we do not believe that first of all, I haven't figured out what method the people might use, but just assume that for the sake of argument, what they do is call Detective Zoller to testify this letter came into his possession through whatever means officially the people are prepared to say they got it. Court says it's handwriting. Lyle Menendez's handwriting is identified. Miss Abramson says, there will be some identification. It is Lyle's handwriting. It is a partial, not complete document. It has no complete date. There is no evidence that the people can produce concerning whether it was ever received by Tracy Baker. There is no evidence that the material contained in the letter is false. That's the groundwork. And so the question is whether or not they can simply float that thing in front of the jury and then argue that Lyle Menendez suborn perjury or was trying to suborn perjury when they cannot prove that the material in it is false. That's not the same situation as the Brian Eslaminia situation where we know the material is false because Mr. Eslaminia, first of all, we know he got it. We know there were discussions that he had with Lyle Menendez about the contents. We know his understanding was he was being asked to, or he had volunteered to perjure himself, and that the material in that letter was in fact false. We don't have any of that information concerning the Tracy Baker document, and therefore we don't believe that it is a proper impeachment under 1202 because it doesn't really prove either duplicity on the part of the hearsay declarant prior testimony, uh, testifying co-defendant, since they can since they can't prove the foundational facts that it's false. Since I am calling the witness, I can't make the prejudice argument to my client, I believe. The court says, could it not be, even if you couldn't be established to be false, evidence of coaching of witnesses by the defendant? Ms. Abramson says, I don't know that coaching of a witness about something truthful is by itself proper impeachment. It isn't a prior inconsistent statement. It isn't consciousness of guilt. It isn't an effort to suborn perjury or to have someone bear false witness. I don't think coaching rises to that level. And if that's all it's supposed to be used for, if that's all they can say about it, then I think the prejudice value that the jury may assume the information is false, though it can't be proved, outweighs the probative value of coaching witnesses. So, in that sense, I don't think that's good enough. Given the nature of the piece of evidence, the limitations of the information that the prosecution or any of us, in fact, have about the foundational issues, such as receipt by the witness, use by the witness, and falsity of the underlying information. Is there anything I missed? The court says, okay, let me hear. Ms. Abramson says, also, Your Honor, just so the court knows, yes. It also opens the door to litigation about the provenance of that particular, and it is only a copy, mind you, and only appears to be only 2 pages of 3 pages of something bigger. The court says, right. Ms. Abramson says it also is going to open the door to a lot of litigation about the provenance. The story that's told by the person who supposedly turned that over to the incredible, or that turned it over is so incredible. This is Miss Novelli. It just suddenly appeared in her mailbox. I mean, it just leads to a whole bunch of other litigation, and it involves Dominic Dunn. Who is Dominic Dunn? He was famous. I know he had a daughter who died. Hold on. I gotta look this up. He was a reporter, I want to say. Hold on. Yeah, okay. So Dominic Dunn was an American investigative journalist, best-selling author, and a Hollywood producer. He's best known for his gripping true crime coverage of high profile celebrity murder trials and his explorations of the dark side of high society, power, and privilege. That's according to his Wikipedia page. Um, Journalism, true crime. Before he was a writer, he worked in the film and television industry. He produced pioneering gay film The Boys in the Band and The Panic in Needle Park. Those were 1971 and 70 films. Um, yes, and then his daughter, Dominique Dunn, she was the oldest sister in Poltergeist, and she was unfortunately murdered during the making of that film, or I believe it was during the making of the film. They couldn't finish some of the parts without her, or they had to rewrite some of the parts without her. But anyways, she was murdered by, I want to say, her boyfriend, and it's not telling me. But isn't that wild that he's an investigative journalist on true crime and then his daughter becomes a true crime case? She was at her West Hollywood home in 1989, rehearsing a scene with a fellow actor. Sweeney arrived at the house Sweeney was the ex, the boyfriend, or John Thomas Sweeney, who was a chef in Los Angeles and a psycho. Um, she broke off the relationship and had moved out of their home. But then later, Sweeney shows up at this studio or whatever, this home where she's rehearsing. And when she stepped outside to the driveway to refuse his request to reconcile, Sweeney attacked and strangled her until she lost consciousness. I never read about this. Okay, Parker found Sweeney kneeling over the other actor that she was rehearsing with, found Sweeney kneeling over her body in the bushes and called the police. Dominique was rushed to Cedars-Sinai Medical Center but was declared brain dead. Her family kept her on life support for 5 days before making the agonizing decision to remove it on November 4th, 1982. That's tragic, man. I never knew all the details about that. I just knew her boyfriend was a psycho and came after her and killed her. But yeah, so Dominic Dunn is the journalist, and she just referenced it involves Dominic Dunn, and the court abruptly cuts her off when she brings up Dominic Dunn. Maybe there's a reason for that. I don't know. Maybe he doesn't want to talk about the high profileness of the case. I don't know. He says it doesn't involve anybody other than the author, and it's identified by his own handwriting. Ms. Abramson says, going back to the letter that's supposedly or allegedly Lyle's, Ms. Abramson says, but on this issue that it was ever sent or received, so it could have any relevance on the issue of suborning perjury or even coaching a witness. If the witness never got it, then how this particular copy got to the police hands where we have very rather mysterious information, I think does become relevant on the question of whatever happened to the original, if anything, since the people can't answer that question of what happened to the original. The court says, what is the position of Lyle Menendez in regard to this, since he is obviously not offering his own former testimony, but his case might have some impact or be impacted in some fashion by this evidence? Mr. Gessler says, my position, Your Honor, is that we, assuming that we take the position that we will not call Lyle Menendez, which is, as the court has said, is to be made at a later time, but assuming that for purposes of argument, so that this discussion becomes relevant, the court says, right? We feel that it would be harmful to Lyle Menendez, who is not offering his own testimony, to have this letter come in against his credibility, basically, when he is not testifying and putting his own credibility into issue. So he can't speak to the letter because he's not coming. I don't think this letter ever came out in the first trial. This is a letter where I think he was writing to his girlfriend to ask her to lie or something, and or supposedly, I don't even know for sure, but they're arguing some letter that Lyle allegedly wrote, which is asking possible suborning perjury, in their trial. But this would have been this conversation, all these like perjury conversations, all the lie for me on the stand conversations were happening before their first trial, the 1993 trial. So the murder takes place August 20th, 1989. Their first trial is between 92 and 93, I think. And then their second trial, obviously, now we're in 95 and 96. So I forgot where I was going with that, but just to give you a timeline. Anyways, he's saying that he feels it would be harmful. Court says, right. Mr. Gessler says, we feel that it would be harmful to Lyle Menendez, who's not offering his own testimony or the letter. The court says, okay, all right. This is a I will hear from the people in a moment. Just a sidelight. In the first trial, when the defense began its presentation of evidence and came to the point of introducing the testimony of the defendants, Lyle Menendez testified first, and the counsel for Erik Menendez vehemently objected to the jury dealing with the case of Erik Menendez seeing or hearing the testimony of Lyle Menendez. Ms. Abramson says, right. The court says, and I assume that that was a good faith argument made at that time it was made. And now we hear the argument of Erik Menendez that the testimony of Lyle Menendez should be heard by the jury deciding his fate. Ms. Abramson says, I can give you a candid reason for that, Your Honor. The court says, likewise, the position of Lyle Menendez was that the jury of Lyle Menendez should not hear the testimony of Erik Menendez, and that was vehemently argued by counsel for Lyle Menendez. It doesn't involve you at this point, Mr. Gessler. You weren't there, and you're not offering the testimony of Erik Menendez. So, Ms. Abramson says, it was made in good faith, and there is a very simple answer, simple reason. I will be candid with you. I didn't think Lyle Menendez was going to be a very good witness, frankly, and I didn't know him as well as I know my own client. I think that after he had testified, I reevaluated that he was a good witness, and if he had not been a good witness, I probably wouldn't want to use his former testimony, but I would have preferred then, just as I would have preferred in this go round, to have two completely separate trials. But we're not put in that position. And a lot of evidence has come in that was supposedly limited only to Lyle Menendez that was very damaging to him that I believe spills over to my client. So I have a tactical and strategic reasons now where I'd like the jury to see the other side of Lyle Menendez, if you will, because my client's defense has been tied to his much more closely in the trial by the mere existing of only one jury. It's not mysterious. That's nothing devious about it. I would have preferred total separation the first time around. But since we don't have total separation, and since I believe he was a truthful and compelling witness the first time around, and since I believe he can corroborate some of the crucial things that my client has testified to, and you know, I can't call him as a live witness. I think he'd be just fine as a live witness this time around, too. That's the best corroboration I can get, and only available corroboration for some of the facts that my client testified to. Good reasons. And it made total sense. And in my mind, as soon as he was asking that, I'm like, why do you think that? They had two separate sets of jurors. This time they don't. So why does it matter? The court says, well, this eventually of one defendant offering the former testimony of another is something that I brought up as a possibility in earlier discussions here just to get the people's position because it is certainly something one could envision occurring that there would be such an offer, and I solicited several times the people's position and authority for the position that such evidence was not admissible. Let me get back to the Tracy Baker argument. Mr. Khan, did you wish to argue that as to how you propose to introduce the evidence and its relevance? The Tracy Barker or Baker letter. That's who he was writing. I knew it was a girlfriend and it wasn't Jamie. Couldn't think of her name. So that's the letter that they've been arguing this whole time. They don't even know if it was sent, received, acted upon in any way. It's just a letter that was found and mysteriously put into the hands of the police somehow. Mr. Khan says, did you wish to argue that as to how you propose to introduce the evidence and its relevance? Mr. Khan says, this is something that I think is going to require some additional thought on our part as to how we intend to use it, simply because we're not at this stage of the proceedings right now. I think that we're deciding this issue somewhat prematurely because it is only when the defendant decides to present the one of the defendants decides to present such testimony that the prosecution is then put in a position to rebut that testimony. So I don't think that the court is obligated at this time to give the defendants previews or assurances as to what is and is not going to be admissible in rebuttal to such testimony. The prosecution may have some additional ideas for the introduction of rebuttal material once the defense decides to present some testimony. So I think that's going to require some more thought on our part. Court says, all right, certainly, if the prosecution has rebuttal evidence and impeachment evidence, rather, it is not obligated to disclose it at this stage, and the defense for Erik Menendez is operating in the dark in that regard. If the prosecution does have other material that it has not disclosed to the defense, that would be of an impeaching nature to Erik Menendez. Ms. Abramson says that's not true. Under the modern rules of discovery, they do have to give us their rebuttal evidence. The court says witnesses, witness statements, but something else they have that would only be used if something occurred. It would be impeaching. If it would be impeaching. Ms. Abramson says they also have to give us, under all the rules, federal and state, statements of a defendant, which is the basic type of impeachment. I'm not worried about anything else, Your Honor. I just want to get the given. Get the given. The court can't make rules about what it doesn't know about, but we have known all about the evidence for a year and a half. Court says, let me just say, as far as the Tracy Baker letter is concerned, when I ruled on that issue in April of last year, I indicated that it wouldn't be admissible in the people's case in chief, but was the type of material that one could visualize being used as impeachment evidence. And at that time, my observations were in regard to the actual testimony of Lyle Menendez. We're faced with a potential. So, is he telling the prosecution how to do the case? He's like, well, I don't think it should be impeachment material, but, or whatever. I don't think it should be in the people's case in chief, but it should be the impeachment material. Like telling him, giving him strategic tips or something. Is that even allowed? I don't know. Does that count as him trying to tell the prosecutor, do this and I'll give you, I'll give it to you. I'll rule in your favor. Judge goes on to say, we're faced with a potentially different situation of former testimony of Lyle Menendez being presented. A declarant whose testimony is offered is subject to impeachment under Section 1202 of the evidence code, and the mechanism for impeachment is the same as though the witness had testified, except that since it's former testimony, the witness need not be first confronted with the material before it is offered as impeachment, because it is not possible to do so because his former testimony is being offered. Mr. Gessler says, I am aware of 1202, and that reinforces my problem that I mentioned before as to the prejudicial aspect of this testimony coming before a jury who is also judging Lyle Menendez when, if this situation arises, I have not called him as a witness before that jury. And although 1202 certainly comprehends the usual trial situation, this is an extremely unusual trial situation where co-counsel wants to use my own client's statement and then risk impeachment of him before a jury who is also going to be trying him when if this comes about, he is sitting here at the counsel table and not saying anything. I think that that's a situation not envisioned by 1201. Mr. Khan did not address the court's question as to how to deal with the prejudicial aspect of this against my own client, Lyle Menendez, should that Tracy Baker letter be used. The court says, well, you don't address the other aspect of it, the argument people make on grounds of unfairness by the defendant or the co-defendant offering the testimony of Lyle Menendez. Lyle Menendez is the beneficiary of that former testimony, and that testimony is would be presented to the jury deciding his case without his taking the witness stand, and he would be the beneficiary of that testimony from the first trial. Mr. Gessler says, I guess that's true, Your Honor. But we didn't ask for this joint trial. In fact, we opposed the joint trial. We still do. And if this situation comes to pass, I will renew my motion for severance because I feel The court says, let me stop you for a second. I suppose if you felt that way prior to the trial commencing, that you could have added this as a basis for the motion for severance. Ms. Abramson says, do you want us to be crystal ball gazers, Judge? Like, do you want us to predict everything, every situation, every possible thing that could happen? The court says, I am just telling you that the motion for severance was most prop, propitious. I'm not even going to say that word. Was made prior, propitiously made prior to the commencement of trial, and this is certainly something that could be envisioned, something that I was talking about before the trial started. Mr. Gessler says, certainly we waived many grounds for motions of severance with the Aranda grounds and everything else, Your Honor. I don't know if we specifically mentioned this particular possibility coming up 3 months later, but it's just one of those situations, such as Matola said, that often a joint trial is a harbinger of failure, although that had to do with an editing process. The problems that can arise in a joint trial are many and cannot all be particularly foreseen, although some can. But it was the people's position to go forward with a joint trial. They made that decision knowing that courts' warnings that problems can arise in a joint trial that might hamper their ability to present their case in the same manner which they that's a good argument. In the same manner which they could if they were trying these two men in a series. That's a good argument. The court says, but if you go back to the hearings regarding the motion to sever and the people's offer of testimony of each defendant through Detective Zoller, the defense response was, well, if they put on part of it, we want to put on the rest. And the court ruled in favor of the defense that if the people put on part of it, you could put on the rest. And Ms. Abramson took the position she didn't want to put on all of it, just portions of the rest of her client or Lyle Menendez's testimony, rather, and you took the position that you would put on all the evidence, all of the testimony of Erik Menendez, not just portions of it, but all of it. That's basically how this discussion took place before the first trial. So you, at that point, were envisioning all of Erik Menendez's testimony coming before the trier of fact. Ms. Abramson says, we're talking about 356, though, Your Honor, if they had some. Mr. Gessler says, this was if the prosecution took the initiative and put forward one part. That is a different posture because now they are putting forward part of the statement whether made to a police officer, whether made under oath, whatever it is, invoking then the entire statement for the declarant who was the defendant. If that had happened, that would have been my position, but it didn't happen. Court says your position in your written motion and perhaps in oral arguments was that really the exception for the admissibility of the evidence was former testimony and prior testimony, and that's how it should come in. Mr. Gessler says, provided they did what they said and took out a very small part, which was an admission, a confession practically, to having done the case, although not a confession as to what it is, murder versus manslaughter. Had they taken that step and put on that part, that would still be my position today, but they didn't. So that's kind of now immaterial because now we're in the defense and different postures and different evaluations of the evidence come into play. The court says, well, if we were talking about an out of court statement made by Lyle Menendez, say a declaration against penal interest or something else that Erik Menendez was then offering in his defense, and then the people, because of the offer by Erik Menendez, put on some impeaching evidence of the declarant under Section 1202 of the Evidence Code, your argument might have more merit. But what we're talking about is the former testimony of Lyle Menendez, where he testified under oath. He took the stand on his own volition in the first trial and testified, and now that evidence is being offered in this trial. And Mr. Gessler says it's not being offered by me. The court says, I understand that. I understand that. The people don't argue this, but I get the impression what they're really saying, although they won't articulate it, is their position is you really are offering it. Mr. Gessler says, you mean they think we're a conspiracy? which is what he said. The court says that Lyle Menendez and Erik Menendez are putting on a joint defense and jointly presenting their case, and that really this is evidence that would benefit not just Erik Menendez, but Lyle Menendez, and then insulate him, Lyle Menendez, from contemporaneous cross examination before the jury. That's the people's argument. That's interesting, says Miss Abramson, but I don't feel like discussing with the people our strategies or lack thereof. That's just speculation on their part, Your Honor. Court says, let me get back to what I'm saying. Regardless of how you look at it, the testimony offered by Lyle in the first trial was offered, one would assume, because he felt it was beneficial to his case. And he would be, as a byproduct of the procedure proposed by Erik Menendez, the beneficiary of that testimony in this trial. And the people's position is not only as to the proponent of the evidence, Erik Menendez, but also as to the beneficiary of the evidence, Lyle Menendez. They should have a right to impeach that evidence. Mr. Gessler says, Your Honor, my position is I, as counsel for Lyle Menendez, should be able to make the determinations as to what is beneficial to him and what is not beneficial to him and make that decision when I elect whether or not to call him to the stand or not. That is the decision of counsel and the defendant jointly conferring and acting together. It is not Mr. Kahn's decision. It is not Ms. Abramson's decision. It is our decision. And if I decide not to call him because in this trial I don't think it will be beneficial to him, and if I don't call him, that will be why. Then I should not be overruled on that because co counsel has different reasons for putting on parts or all of what my client's testimony, which was beneficial to him at the first trial, that was that trial, and this is this trial. The court says the only person who could overrule you is your client. That's true, says Mr. Gessler. The court says, let me say this then and get to the heart of the issue regarding the Tracy Baker letter. It's hard for the court to commit to a ruling for this reason. Until I hear the nature of the evidence offered in the former testimony of Lyle Menendez, I won't be in a position to rule upon what evidence is properly impeaching evidence until I hear his. This is such a backwards argument. Like, there's no winning. You can't win an argument like that. And it's stupid. Like, I can't argue it until I hear it all, and then, or I can't rule until I hear it all. Well, actually, you could probably just rule from what you've heard so far, but he doesn't want to do that. And we've heard that there are going to be objections to portions of that testimony. A ruling will be made. There is also going to be, before this trial ever gets to that stage, other evidence offered in the trial by other witnesses, and I don't have any way of evaluating how all of those other witnesses and the testimony offered by those witnesses will interrelate with what might ultimately be offered by the prosecution to impeach the declarant, Lyle Menendez, under Section 1202. My initial reaction is similar to what it was in April of 95 when my ruling was made that this is material that could be used it could be used in the impeachment of Lyle Menendez. As to the mechanics of how it could be done, I can't say at this point, and I'm not making a binding decision. If you're asking my client or my current thinking on the subject, that is basically it. That I can visualize it being utilized under certain circumstances to impeach under Section 1202 the former testimony and the declarations of Lyle Menendez. Mr. Kessler says, okay, well, my position has been, I think, stated, Your Honor. The court says, right. Gessler says, and I would state it also under the Due Process Clause and the Eighth Amendment and 14th Amendment, although there is no case that I know of that has reached this very issue because it is a unique situation. But what the court is saying is that there could be a situation in which co-counsel, by virtue of selecting parts of my client's testimony at a prior trial, can put my client in the situation of being impeached when he doesn't take the stand by very harmful information to his detriment when he is not even calling himself as a witness. And I think it is not a unique situation in the law. But I do feel that it would be a violation of due process to proceed in that way, where my client's fate is left in the hands of co-defendants counsel. Sorry. The reason we have separate counsel is to make those decisions separately. So he doesn't even want Lyle's testimony to come in necessarily. And I am willing to be bound by any decisions that Ms. Abramson may make on behalf of her client, and I am unwilling. Did I say willing? I am unwilling to be bound. They think someone's home, but they thought they heard the garage, but that's not the case. Sorry, let me continue. I am unwilling to be bound by any decisions that Ms. Abramson may make on behalf of her client, which are inimical to my own client. There's so many big words. I don't feel like looking them up. I'm sorry. If you guys want to, go for it, but I'm not in the mood. which I feel I should have the right to make those decisions for. So he's basically saying I should be making the decisions for Lyle, not Ms. Abramson. The court says, right, your arguments as far as your role and your function in relationship to your client is clear, and I don't dispute that that is your role and not that of Ms. Abramson or counsel for the co-defendant. But still, I can only go so far without being in a position of having heard whatever other evidence would be offered to make a I can't make a binding decision as to the use of the Tracy Baker material, but I certainly stand by what I said before. It certainly appears to be impeaching evidence of the nature that could be admissible to impeach the declarant, Lyle Menendez, as to whether it ultimately would be, I don't know. Some of the arguments made by Mr. Gessler depend upon or rely upon the fact that this court, ruled that the evidence wasn't admissible in the people's case in chief. Perhaps some other court, appellate court, might have thought otherwise, that perhaps it was admissible in the people's case in chief, and it just turns out that it might be received later on in the trial. I don't know, but at this point, in my view, I can only say that it could be offered. Whether it will be received, I don't know. Mr. Gessler says, as the court knows, whatever some reviewing court may determine is not something that I can foresee in a crystal ball. And I have to determine whether Lyle Menendez, the defense strategy, whether or not will testify based on the state of the record on that very day when we get to that point. And that's the trial record in this court based on the trial rulings in the court upon which we rely to have an orderly and just trial. The court says, absolutely. Mr. Gessler says, and so I can't look into a crystal ball as to what some appellate court may say was harmless error or something like that. I would agree anything of this nature to be extremely harmful error, which is why I am taking my time, obviously, to oppose it. I think it's crucial, it's key, and obviously would be one of the considerations that I have in mind as to whether or not to call my client. I mean, the court understands that we weigh the value of testimony versus potential harm in some cross examination, and that is an assessment I am making every day as we see how the evidence before this jury proceeds in this trial. The court says this is the type of an assessment I have to participate in as well before making a final decision as to what can and cannot be used for impeachment, if and when the former testimony is presented, so I basically can't make a ruling on it until we get to it. Ms. Abramson says, I feel like I am somehow in the middle of a circle here because if I don't have some indication, I mean, I have a certain amount of discretion to exercise too here, not of course with the importance of the court as to whether or not to proceed with offering this. I mean, I am getting some feeling for how the court feels about the Tracy Baker issue. I want to go on to some of the other impeachment issues. The court says, I'm saying I can visualize it being used. As to how it's used, that's as much as I can say at this time. It's not a binding decision. It's nothing more than based upon some oral arguments about having all the information before me, such as all the other evidence that will be offered and the proposed testimony of Lyle Menendez, plus all other witnesses that might be offered before we get to that stage. That's as far as I can go. Ms. Abramson says, okay. The next area that we were concerned about was, and this is a little harder to deal with because the people haven't indicated what specifically they're seeking to use for impeachment, but There are the Norma Novelli tapes, and one of them we have had extensive litigation about, the so-called tape 25. Then that's the one that has to do with Lyle Menendez's reaction to a day of Dr. Oziel's testimony and things that he was saying about Dr. Oziel in his own musings. The court may have that in mind. The court says, yeah, I do. Well, first of all, did the people intend, if the testimony, former testimony of Lyle Menendez was offered, to limit yourself to just that tape? There was some indication last week when we discussed this, or 2 weeks ago, that you indicated, or that you intended to use more. Ms. Abramson says, yes, that's what I'm trying to find out. Mr. Khan says, yes, the people initially proposed that we use a specific tape in our case in chief, and we felt as part of our case in chief that would be admissible. However, if the testimony of Lyle Menendez is presented and we are permitted under Evidence Code Section 1202 to present impeaching material, then that may very well exceed the material that we intended to present in our case. So I will have to review the tapes once again after the former testimony of Lyle Menendez has been presented before the jury to determine what is going to be presented. Ms. Abramson says, Judge, at some point you reach gridlock, and I think the people are being purposely obstructionist about this. They don't want to say what they are going to use, so I can never make a decision. They say they want to wait until after I proffer the testimony, but I am trying to decide whether to proffer it. Since we know what the testimony is, it's not speculative what he said before. I am trying to get some indication, just as if I were conferring with my own client and making what the old school called a beagle motion. Are the priors going to be admissible so I can make that decision about whether or not to call through prior testimony Lyle Menendez? And it's very useful for the people's purposes just to make me not do that. Yikes. Do you guys understand what's going on? I kind of do. They're arguing mostly about what comes in. It's an issue with, who now we have one trial versus two trials. And Ms. Abramson wants to put on Lyle's testimony, the audio video of Lyle's testimony with redactions, of course, based on objections by the state. But the state is being extremely difficult. They don't want to go through the testimony and say, we have objections with this, we don't want this coming in, which is what they really should do. But they don't want to do that because it's hundreds of pages long, and I get that. But you can't just be every time there's like another solution Ms. Abramson tries to offer, they say no. Everything is a no. We can't do that because everything is, they don't want to help. And then with the judge saying, well, I can't make a decision until I've heard the testimony, but Ms. Abramson can't make a decision about her case until she's knows what the rulings are and what his decisions are. So it's like a never-ending circle, and you're never going to get what you need. At least the defense isn't. She goes on to argue they obviously don't want me to call him as a witness in that manner to hide the ball about what is, and this is not a secret, discovery secret. We have all the Norma Novelli tapes, so it isn't a matter of the people hiding or being able to keep to themselves rebuttal impeachment. It's all there. The question is, what do they consider impeaching out of this huge number of tapes so that the court can get some feel for whether or not it is of the character of materials that ordinarily would be impeaching. Even if the court is not in a position now to say absolutely this evidence would be admissible until the court's heard all the rest of the evidence, as the court has just indicated about the Tracy Baker thing. But I mean, it's just silly for the people to say, gee, I have to review. They know. I am sure that they know what they would use if Lyle Menendez were to take the stand next witness, that they know what's in those tapes, what they consider impeaching, and it isn't a matter of their prerogative of discovery. Since we have the tapes, they are the statements of the defendant, and they don't have any right to hide them, and they haven't hidden them. We have turned it over, or they have turned it over. So I think if today is not the day, perhaps Monday is the day to have them say what is it they believe is impeaching that they should have a right to use so that we can evaluate. The court can get some feeling for it and we can evaluate whether or not the risk of is worth using the prior statement of Lyle. The court says, well, let's start with the one audio tape that they indicated that they intended to use. What is your argument about that? Ms. Abramson says, well, I don't believe that that is actually impeaching in any event. It is the musings of Mr. Menendez following testimony by Dr. Oziel that he felt was deceitful. He is angry and upset. There are no steps ever taken. I suppose the point of it is a willingness on his part to fabricate. This is nothing but a thought. There are no steps taken. No one is ever contacted. Nothing specific is ever discussed. No fabrication is ever presented. And that's the end of the story. So it seems to me that we are really in the realm of mens rea without actus rea of any kind, and this is the kind of unreliable and speculative type of evidence where the prejudice outweighs the probative value. Court says, okay, did the people wish to argue that one? No, not at this time, Your Honor. Okay. Mr. Gessler says, I would simply add, Your Honor, that my arguments as to that Norma Novelli or any Norma Novelli material are the same arguments I made earlier as to Tracy Baker on the same constitutional grounds. The court says yes, and obviously, if it came to that point in the trial where this evidence was actually offered, I'm sure you would want to, at the very least, incorporate these arguments or argue it further. This is just, at this point, a very preliminary discussion on these subjects. Again, that was an area that the court felt, as far as that one audio tape, was more appropriately used in rebuttal, not in the people's case in chief, overcoming various objections by the defense to its authenticity and objections regarding its admissibility on grounds of violation of federal and state law dealing with the matter in which the material was obtained. The court was then presented with additional objections by the defense relating to its admissibility, and the court dealt with it. I'm trying to find the minute order. The court dealt with it by minute order of August the 29th, and the court stated on that date in the minute order, the content of the tape involves statements of Lyle Menendez related to certain testimony of Dr. Oziel presented by the people. These statements were made during the first trial while Oziel was still testifying. No evidence has been presented to the court that Lyle Menendez did anything to follow through on the discussions contained in the tape number 25. Further, the people have stated that they will not call Dr. Oziel during their case in chief when the proposed redactions are combined with the fact that the jury will neither see nor hear Oziel's testimony in the people's case in chief. The probative value of the evidence is substantially outweighed by its potential danger for confusion of issues and of misleading the jury. Further, an undue consumption of time would be required to place the statements in proper context in relation to Oziel's testimony from the first trial. The defendant's objection under Evidence Code Section 352 is sustained, and the people will not be permitted to use the tape in their case in chief. This analysis only applies to the people's offer of the evidence in their case in chief. The last sentence was included in my ruling so that the parties would be aware that this evidence, could be the subject of a new offer by the prosecution in rebuttal for purpose of impeachment. At this stage, the jury knows more about Oziel than they did in the people's case in chief. They know that through the testimony of Erik Menendez. The testimony is not yet completed, and also, assuming testimony is offered, former testimony of Lyle Menendez is offered by Erik Menendez. They'll know more about Dr. Oziel and his relationship with the defendants depending upon how much testimony is admissible and received in evidence from the former testimony of Lyle Menendez about Dr. Oziel. Ms. Abramson says, we propose to edit it all out, Your Honor. The court says, I know you do, but the people have a right to have it in, and if that is in, or a good portion of it is in, then there would be the factual basis and the foundation for a jury to understand what it was that Lyle Menendez was talking about in his audio tape. Until Erik Menendez's testimony is completed, until Lyle Menendez's former testimony is offered, and to the extent of reference to Oziel and his relationship to Oziel is before the jury, I won't be able to make a final decision on this. But it seems to me that the people would be in a much stronger position to argue that the evidence would be admissible for the purpose of impeachment than they were prior to the trial, prior to any evidence offered regarding the relationship of Oziel to the defendants, none of which was brought out during the people's case in chief and has only come in through the testimony of Erik Menendez so far and would be brought in further through the testimony of or further testimony of Lyle Menendez. So again, it could, depending on how things develop, it could develop that this evidence, tape number 25, as it was identified, could be proper impeachment of the former testimony of Lyle Menendez. Abramson says, Your Honor, my only response to that would be that it still wouldn't make sense to take the first prong of the court's analysis as reflected in the minute order. It still wouldn't make any sense unless the jury were somehow told, and I can't think of any way they could be, what Oziel's testimony was on the day that Lyle Menendez is reacting to on the phone that night, if it's night. And I see no way to bring in that piece of Oziel's testimony in order to give meaning to Lyle Menendez's sense of upset and outrage about Oziel being untruthful. So something about, is this a audio call of like a phone call, a prison call of Lyle or something? I don't know what this tape is, but he's angry because Oziel's lying on the stand. It's one of the days that Oziel testified on the stand, and Lyle is talking about it afterwards in his cell to somebody or in jail, presumably, with somebody about it, and he was upset. He says, or she continues on, I think that's the core issue, not is there an Oziel and do they have a relationship to him? But what was it Oziel was saying that triggered this reaction by Lyle Menendez? So, unless the people can call Oziel and somehow elicit the same information, I still don't think the Norma Novelli tape is relevant in a factual sense. That's right. I had to look it up. I forgot who Norma Novelli is. She is a wackadoodle who decided she was going to befriend Lyle Menendez while he was in prison, and then she tape recorded all of their calls and I guess turned it over to prosecution, or she wrote a book. I don't know. No, that's not true. I'm just perusing an article from the LA Times and I'm trying to find out. Novelli testified Lyle broached the idea of a book, and the original plan was to detail his experiences in jail and the other side of Lyle, meaning his personality, things like that. She testified that he told her, when I do my book, or he might have said, when we do our book, I'd like to go on tour with it. Mm-mm-mm-mm. Anyways, yeah, so she took a bunch of tapes from her and Lyle. Lyle never gave his consent to Novelli for all these tapes. So did he know she was taping him? Hmm. Okay. I've got answers. So Norma Novelli, she claims that Lyle gave verbal consent to record. He says he vehemently denies that he ever consented. He never knew. He didn't know that she was even recording. She never obtained his consent in writing or on the audio tapes themselves. But yet, the judge ruled that Lyle consented because it's Judge Weisberg, and we know he's going to rule in favor of the prosecution in any way. And how did the prosecution how did the prosecution get the tapes? After Novelli sold the tapes to a book publisher. It triggered a legal chain of custody. So once that came about, then they had to go get bring it into custody appropriately. So that's who Norma Novelli was, and that's what they're arguing now. I forgot about that. I remembered him being like befriended and recorded after the first trial, I think, or maybe it was during. But this I don't think came in the first trial, or did it? That I don't remember. But I remember her name, so she had to have come in. All right. So the court says, okay, well, I disagree because there would, at that point, be a lot more evidence before the jury of what it was that Lyle Menendez was referring to and the relationship between the defendant and Oziel, all of which this jury had no way of knowing and evaluating in the people's case in chief, but would have based upon the testimony of Erik Menendez and whatever former testimony of Lyle Menendez that is presented. So I can envision again that this could be used for impeachment. I can't make a final ruling until I've heard all of the evidence regarding the relationship of the defendants to Oziel, but again, I can visualize that evidence being used for the purpose of impeachment. This is such a backwards way of doing it, and it's making it impossible for the defense to make strategic decisions for their case. They're just like in limbo waiting for the judge to hear it all so then he can rule. But they need a ruling now so they can put on their defense. What does he say next? As far as the other material in those tapes, I agree that the people probably never viewed the tape with an idea of using it if Lyle Menendez testifies all the tapes. However, they are not in a position to make any final decision until they know what it is or what is and what is not admissible of Lyle Menendez's former testimony, and they won't know that until I rule on it. Ms. Abramson says, right, which gets us back to the circle. That's why it's so important. The court says, no, it's not a circle. Sir, you are absolutely creating an impossible situation for the defense. It is absolutely a circle. He continues, saying, your offer is to offer the evidence. If you offer it by a mechanism where the court rules, objections are made. There is no requirement that Erik Menendez have the rulings in advance. I've given you some preliminary indications as to those things that the people have indicated they would offer that you know of right now. You get a sense of how I look at it. That's as far as I can go. I don't think you can force the prosecution to tell you in advance what it is that they would or would not use any more than they're required to do so before the defendant testifies. Assuming Lyle Menendez said, I'm going to testify, the people wouldn't have to commit themselves to what portions of the tape they would or would not use before he finishes testimony. Ms. Abramson says, then what's the whole purpose of an in limine motions, Your Honor? It is to anticipate these very issues so that you can make informed strategic decisions. That's why we move in limine. That's why we don't wait until matters have gone before the point where certainly prejudicial evidence would be permitted. And the circle is if the court will not allow a procedure by which we know precisely which evidence will be offered because the objections can be ruled on in advance of his testimony, which is given, it's not speculative that it would be. Then what's happening is the court is putting me in a position where I have to simply roll the dice. Number one, I have to roll the dice on what will and what will not be admitted in his testimony because the court doesn't want to rule on those issues. If the court's ruling on the other day is still your fueling, I have what? I have to rule, or I have to roll the dice on what it is that could open the door to impeachment, not only of two things I know they're offering. Not only of the two things I know they're offering, but of who knows what else they may view as impeaching. And I don't think it's fair to me and to my client, to the defense, to make it that impossible for me to make an extra strategic decision, a decision that may have enormous importance with respect to credibility of the entire defense and my client's entire defense for convenience factors. I mean, there is no reason why we can't know in advance what part of Lyle Menendez's former testimony would be admissible, and then there's no reason, once that is known, that objections have been sustained and what is admissible. There's no reason at that point why we can't have in limine rulings that seek to prevent or permit, as the case may be, the people using certain hearsay to impeach. I mean, if necessary, we'll go through the Novelli tapes and point out all the things we don't want them to be able to use. We do. We do that all the time. It's the flip side of our coming in and asking for an in limine. We can do that without them saying they want to use it. We can do those things and point out. We could say each and everything. The court says, well, counsel can ask. Ms. Amberson says, we're moving in limine. That's the point. The court says, counsel can ask for in limine, but there's no requirement they be made. You can ask for all sorts of things. Such an ass. Ms. Abramson says, we have a lot of talk about fairness to the prosecution, which seems to me have not been in any way hampered in this trial, and we want to talk about fairness to the defense, fairness to our right to make informed decisions about how to proceed in this case. We've had enormous litigation placed on the kind of evidence we can bring out in this trial. We've had the order of our witnesses virtually dictated by rulings of this court that certain things can only be relevant if other things come first. We're walking a tightrope with severe constraints on us. And I don't think it's fair to us to tell us, well, take your chances, folks, and you'll figure out in front of this jury what part's coming in and what isn't. She's absolutely right. And then what impeachment the people may use and may not use when things are known and are knowable in advance. When things are not known and are not knowable in advance, I agree. The court says, let me interrupt just for this observation. The people had a broad objection to much of the testimony of your client before he took the witness stand. I know that. They knew what his testimony was going to be because he testified in the first trial, and they wanted the court to rule in advance so it would be fair to the prosecution to rule in advance before the defendant testified as to what would and would not be admissible. And the court agreed with the defense that it would wait until the defense testified and when he was asked questions. The court would rule on what was and was not admissible, and this is no different. You look at it staying fair to one side, fair to the other side, I'm doing the same. Ms. Abramson says, I'm not here to discuss relative fairness, just the burdens that this lack of specificity in advance places on us. The fact of the matter is you can speculate that the testimony would be the same, but obviously there's different evidence that he had to deal with, and the testimony was not, in fact, the same. And in going first made his testimony very different because previously all the other witnesses testified first. He didn't have to talk as much himself about certain issues that other witnesses were going to be able to talk about. So I think it was reasonable to assume there would be sufficient enough difference that it wouldn't make sense to rule in advance as to what he could or couldn't say because he didn't know if he was or wasn't going to be asked to say these things at this time. That was very confusing. And yeah, that's not the same situation with the prior reported testimony. It can't change unless there's magic going on. It can't change. It is what it is. It's exactly the same words and exactly the same responses. Exactly. The state has had Lyle's testimony and been preparing off of Lyle's testimony all this time. So why are they not prepared to say what we object to and the things in his testimony that we want not to come in or to come in? Why you've had it all this time. I'm sure you've read it many times. So I don't know. I don't know. The court says until we get to the point of the testimony being offered, it's difficult to evaluate objections on grounds of relevancy and Section 352 because one doesn't know what will have been introduced to the jury by way of evidence, whether from other witnesses, physical evidence, or whatever. He's acting like this hasn't been litigated before, and he hasn't seen a trial in front of him before of these two individuals already. These things aren't that difficult. He's making it more difficult by saying, doing this roundabout, well, I can't rule until I hear all the evidence, and you can't put in all your evidence until I make my ruling. So we're just at an impasse. Really? That seems quite unconstitutional for the defense. Since it's the defense who has a right for a fair trial, not the state. All right. So continuing on, he says, until we get to the point of testimony being offered, it's difficult to evaluate objections on grounds of relevancy in Section 352 because one doesn't know what will have been introduced to the jury by way of evidence, whether from other witnesses, physical evidence, or whatever, until the evidence is offered, the former testimony is offered. There will be a lot of other evidence first before we get to that. For the court to rule now something is irrelevant, something is relevant, something is excludable under Section 352, it's premature to do that. Ms. Abramson says, let's do this then. This is what we would request, that we still should be able to decide before I actually put on the testimony what would and won't be admissible. If that means we have to wait until other testimony has come in from other witnesses, fine. But the real issue that we're still back to the real issue of whether will be allowed to produce whether will be allowed to proceed by way of videotape. The court says, well, you wanted some rulings or indications from the court as to the areas of impeachment. I've already given you those, and apparently those don't deter you from going ahead with the former testimony. Ms. Abramson says, well, I don't know that yet. I have to think about what it means, and we were interested in knowing about these other matters from the Norma Novelli surreptitious library, secret library, that the people don't want to tell us about. But there are two different considerations here. I mean, I will say that if we are limited to using the transcript, which has no demeanor evidence and is extremely cumbersome on the court reporter who, but not for that reason, it's simply not as valuable. The court says the court reporter need not read it. You can have role playing. You can bring Ms. Lansing in to read back. Ms. Bazanich, and maybe Lyle Menendez can read his former testimony from the first trial. Ms. Abramson says that would be adorable, and he can do demeanor if you would say that's okay. Defendant Lyle Menendez, Charlie will play me. The court says, I saw you standing there and I wanted to get to you. If you're finished, then we'll have Mr. Gessler. Mr. Gessler says, I was having so much fun. The court says, okay, Mr. Gessler. Ms. Abramson says, can I be the judge? Mr. Gessler says, one, although this is Ms. Abramson's show and not mine, we had an example yesterday of having a party read something that somebody else did. Mr. Khan put his own emphasis on certain words when he was talking about prior testimony to Erik Menendez, which I believe is totally different than the words Erik Menendez used in the first trial when he actually made the statement. That is what has to happen if a reporter or neutral party or any party ever reads testimony. I don't know if you can hear that. My dogs are wrestling in the background. It might get loud and they might bump into me, so I may have to pause if they do. So this is what has to happen if a reporter or neutral party or any party ever reads testimony is they put their own spin on their words, have emphasis, which totally changes. Hold on. which totally changes often the meaning of the passage that is read. Here we have the actual demeanor evidence, should this come out, of what was actually said and the inflections that were actually used. But the other thing that concerns me the most, and why I've been standing here, is the court said basically, I'm not going to make rulings now as to what passages will come in and what will not. And Ms. Abramson said, well, that puts me in a position of having to roll the dice. Now, it may be that in many cases, defense lawyers, have to roll the dice and take their chances on that, on what will be admissible or how good a cross examiner the district attorney is, or a myriad of things. My dog is crazy right now. He's just running around the house like insane. I'm going to go play with him. I'll be back. I'll be back. We just left off at no matter how good a cross examiner the district attorney is, or a myriad of things. That's part of trial. Okay, we've all settled down now. But in this case, she's rolling the dice with my money. I mean, she's making the choice of what dice to roll and whether she's going to succeed or not. But it's my client's life at stake that she's putting up there when she makes that decision if she's having to act in a vacuum. So I would renew her request. The court says she wants to load the dice, is what she wants. Ms. Abramson says, well, Judge, hold on, we've got puppy incoming. Can you lay down? Ms. Abramson says, well, Judge, am I stupid or what? Wouldn't you always want to have as much certainty about an outcome if you could, about in all seriousness, particularly if you're in a capital trial? This is a death penalty, and your client's life and freedom, at least, is at stake. There's nothing wrong with wanting to have as much certainty. The court says I don't dispute that. Ms. Abramson says this case is so complicated in trying to hold onto its various complexities. It's such an enormous challenge. If I could have some certainty, some control, if you will, over something, it would be nice, because I have had this sense that this ship is out of control for years now, as I'm sure the court can appreciate. Mr. Gessler says, it's not just your client's life that's at stake, Your Honor, it's mine also. The court says there are certainly some interesting legal issues involved here. And what I have done is give you the benefit of my thinking at this stage regarding the people's offer of 2 items of impeachment of the declarant Lyle Menendez, should his former testimony be offered. As far as rulings on objections that the people would make to his former testimony, I again would have to wait until the objections are made, and I don't think it's fair for the defense to expect the prosecution or the court to rule at this stage before any evidence has been received. All other evidence has been received before making a determination as to relevance. Should Lyle Menendez decide, as Ms. Abramson said, to take the stand next week, then obviously the court would have to deal with objections made at that point, because it's his right to take the witness stand, and the timing would be such that it would be certainly appropriate, following the testimony of the other defendant, to take the witness stand. Then the court would be called upon to make those rulings. However, you were just calm. Now I'm annoyed. He can't make those rulings. However, I can't rule on the former testimony until I've heard all the evidence, because that's former testimony is not going to be received until a final determination is made that Lyle Menendez is not going to be a witness. Mr. Gessler says, the difference is, Your Honor, if I should call Lyle Menendez next week or next month, the decision then as to what areas to go into, the guiding hand of counsel as to what questions are asked to elicit the answers, the subjects covered, would be in the control of Lyle Menendez's lawyers, where it belongs. The court says, right, no, I agree, I understand that. Mr. Gusser says there's a difference here, where now that is being put in the hands of co-counsel, making the decision for her instead of my hands for my client. The court says, I understand that. My feeling is the same. I really can't rule at this stage on what would be the people's objections. I think it's premature for them to articulate objections until the evidence is actually offered. Now, as far as the proposal of the defense to digitizing the testimony and the practicalities of all of that, I don't have any experience at all with what you're proposing. If you wanted to create some sort of example or sample for demonstrative purposes to show me, then you can do that and see how it would work. I have no idea as to how the mechanics would work. Mr. Khan says, could I be heard further on that point? Yes. I think we switched somewhere to 1202 without exhausting that. One of the issues I think that needs to be addressed concerning the presentation of the videotapes whatsoever is in relevance to the Moran case, which we've cited in our points and authorities, which indicated that the correct procedure to be followed before the taped presentation is presented to the jury is that the entire tape is carefully previewed by the court and counsel so that all motions, all objections are carefully and thoroughly considered at this time. Now, I don't think that counsel has really thought through exactly how we're going to do this proposed procedure that she's suggesting if we are to present a videotape, if counsel is to present a videotape to the court, which has been digitized and which is then going to contain all of the testimony of the defendant. Either we are going to preview the tape and then we are then going to go through and the testimony and make the objections and get rulings from the court prior to the time that the entire tape is presented to the jury, or we are going to turn on the tape in front of the jury and then we're going to handle objections and get rulings from the court as that tape is being presented to the jury. And I think that either way, it's not going to work out because we have a right to review the tape as it is going to be presented in its final form to the jury. We really can't just present the tape to the jury and start handling objections and get rulings from the court at that time. One of the reasons why is because there is what counsel refers to as demeanor evidence on the tape. What we're going to have is splicing up of the demeanor evidence. We're going to have skipping to certain passages of the tape once we have passed the objectionable material, and we then leap forward to the admissible material. So, what's your argument? That they're not going to have demeanor because you're splicing it up? That makes no sense. Okay. The court says, I got the impression there's some magical way that a digitized tape works that if you have a question asked and an objection sustained, it automatically will go to the next question without, Mr. Levin says, it's scripted by question and answer. Ms. Abramson says, it goes to the next button and the operator stops it at the moment he hears an objection and scripts it to the next question and moves on just the way the reporter would. Don't understand, First of all, Mr. Khan says, if I can finish. Miss Abramson says, I'm sorry, I thought you were done. Mr. Khan says, so the point of that procedure, the problem with that procedure is that we would then be slicing out portions of the defendant's demeanor, which is precisely what they want to get before the jury. Portions of his demeanor. Now we have no idea what the ultimate form of that evidence is going to be to the jury until it has all been presented in front of the jury. And then we'll be able to look back now that it's been presented to the jury and conclude that we'll then have new arguments, perhaps, as to what the overall impact or influence that evidence may have had upon the jury, because only now, at the end of, after it had been presented, will we see its final form. The alternative procedure would be to do it all beforehand. And if we do it all beforehand, once again, we're really going through the process twice. We're presenting all the evidence here in court outside the presence of the jury. We then get rulings from the court as to what is admissible and what is not admissible. We splice it up and then we have an opportunity to review it and look at its final form. Then perhaps we'll have the new objections to the overall presentation of the evidence. I think that is the procedure that is required by Moran for both sides to know what is the final version that is going to be presented to the jury so that both sides can have an opportunity to be heard concerning that material. And I think that the procedure proposed by counsel just flies in the place of Moran. It flies in the place of Moran. I've never heard that phrase. The court says, let me say that Moran probably was decided before this digitizing process ever existed. As I said, if you intend to proceed with this or follow through on it, then the next step would be to present me with a sample of what it is, what you would propose to do. That's all I can say. Ms. Abramson says, this isn't the kind of situation I think envisioned by Moran where you have a videotape that's going to be played uninterrupted for a jury. This is no different than a visual form of the reporter reading the transcript, which would also involve a zillion starts and stops if we don't edit in advance, which the people say they don't want to do. This isn't something the people have never seen. They have the tapes of his testimony, and we can give them a complete set of the format that it's in now with all of the fade outs gone, all the sustained objections gone, all the sidebars gone. The court says, I suggest you give that to them anyway. Ms. Abramson says, we'll give that to them. That's a 3.5 day version, and digitizing doesn't change what's on the videotape. The court says, I'm not saying it did. I'm saying if you have a proposal to do it by way of digitizing and having objections ruled upon and answers stricken or not being presented to the trier of fact, then present me with a sample of it and I'll look at it. It's not like they can just keep playing the tape because if there's an objection, then Lyle might still be explaining his answer and you have to skip to the next question. So that's I'm sure there's software that can do this nowadays. Back then, apparently there was software that could do it then too. So um, where did I leave off? He says, I'll look at it. That's all I can say, but I'm not going to make any rulings on what might be impeaching evidence. I really haven't made any rulings. I've given you indications about how I feel about them. At this point, it's premature to know what else would be offered. All right. Anything else that counsel wants to discuss at this point? There was some discussion yesterday about the defense or the prosecution requesting the court to review testimony of Mr. Chaliff presented during the ex parte hearing during the first trial. Ms. Abramson says they were supposed to submit points and authorities. The court says yes. Ms. Abramson says we haven't received any. Mr. Khan says yes, we may. I don't know when we're going to have that ready. We may decide to simply try to obtain that material to use in our rebuttal case rather than for impeachment of this defendant. The court says, okay, all right. Anything else that counsel want to discuss? We have half day here that we can use for any purpose that relates to hearings that you otherwise would have to conduct. He just came in jumping in the room like crazy. He's still he's just in a phase right now. He's being a puppy, running around playing. Ms. Abramson says, nothing that would require the court to tell us something in advance that the court couldn't feel it's in a position to tell us in advance right now. Does that make sense? I don't know why we should spend any more time when all the court is going to have to say is, I have to wait for the rest of the testimony. I think that's what you would say to anything we have in mind. The court says, I don't know. I don't know what it would be. Ms. Emerson says, I don't have anything else that needs to be decided today. The court says, people have any issues that you feel, come Monday morning at 8:30 or 9. I don't want to get on the bench and have counsel say, well, we have a hearing outside the presence of the jury and we have to discuss something for a half hour, an hour while the jury waits. We're only going to have a half day or a little more than a half day on Monday. Mr. Getzler says, we have nothing further at this point. Ms. Abramson says, I have nothing further. Prosecution? We have nothing further. Ms. Abramson says, can I talk to co-counsel? Defense Counsel confers. Miss Abramson says, "Yes, there is a matter, Your Honor, but we haven't given counsel notice of it, but I'm sure it's the issue that needs notice. I'm sure it's not an issue, sorry. Sure, it's not an issue that needs notice. We believe, based on the cross examination of Erik Menendez, even thus far, that we should be permitted to prove, particularly in the area that Mr. Khan was insinuating, that it is somehow Mr. or Erik Menendez's blame, fault, or responsibility that he did not have more than what Mr. Khan labeled a superficial attachment to his mother. We feel that entire line of questioning about his feelings for his mother and why he couldn't come up with more examples of lovingness on her part and similar questions about his feelings about his father allows us to get into and to prove up why precisely it is, which we know and believe we have expert testimony available to show he does not have other pleasant memories of his mother because of her failings as a mother, because of the way she treated him over the course of his entire life, because of the way she spurned and rejected him from the time that he was an infant, because of the fact that his attachment to her was genuine and was also what is called anxiety attachment, which is the attachment of an insecure child for a caretaker who basically tries to ignore them and shove them off. And we think this should allow us, because of the insinuation of those questions and those questions and answers, to prove up the child development issues involving the harm that parent, the former parenting exhibited by Mr. Menendez and Mrs. Menendez caused to our client, not just because it made the ground fertile for the development of post traumatic stress disorder, which it did, but also because it's the reason why, when all these questions probing his feelings about his parents, it's the reason why he was able to express the feelings that he did express based on the information that he expressed them on. It's very simple that if the only thing your mother ever did was smile, that's the reason why your only pleasant memory is smiling. And the other aspect of this is this I'm not asking permission to prove this. I think we have a right to prove this through the redirect of Mr. Menendez, certainly. But beyond that, I do not believe that it's appropriate that every fact in this case can only be proven by the defendant without corroboration. And we would like to call Dr. Stewart Hart, who is the expert in child development, to testify about the parenting methods of Mrs. Menendez and why that precludes Erik Menendez from being able to give other examples of having more in depth knowledge of his mother to refer to when he describes why he loved her. Dr. Stewart Hart testified in the first trial and talked about the things that she said about post traumatic stress disorder for children and things like that. And the same is true with respect to his father, why it is based on the way he was treated and how that impacted his development and forming attachments, why it is he had the view of his father that he had. I think beyond mental state that the issues of the relationship between Erik Menendez and his parents and the issue of the treatment of him by those parents goes beyond merely forming the mental state issue in this case. It has to do with motive. The people have suggested through their questioning and through their case in chief that the motive here was money, which means a callousness, a lack of regard by my client towards his parents, and perhaps as a sub motive, the motive is hatred. Now, I think we have the right, because of the motive of evidence, to prove what the evidence was in order to prove the genuine feelings that our client had towards his parents and the levels of his affection and regard and the degree to which he was bound to them. And the best witness to prove that, the one with the best credentials, if you will, to prove that, is Dr. Hart, who has spent many years talking to witnesses in this case, talking to my client, who is an expert in child psychology and child maltreatment. And we propose and we are asking leave of this court, since the court has previously ruled he could not testify because of this motive issue, This issue about love and hate and regard of our clients towards his parents, we are asking leave of the court to call Dr. Hart to testify to the nature of the relationship, to the things that were done by the parent that, in the appropriate way under sections 28 and 29, that the things that were done by the parents that gave Erik such a girth of what's the word factors that he could point to justify his love to his parents of his parents, and gave him so little factually that he could call up as examples. Sorry, I have an itch that like won't go away on my neck. And he couldn't call up examples as of to why he loved them, and that is not his fault. That's what happens to children who are raised by spurning and neglecting and terrorizing adults. And we think the door has been opened on this evidence. It is not our intention, unless the court feels it's necessary on a relevancy basis. It is not our intention to have Dr. Hart testify to state of mind at the time of the shooting, but it is our intention to have him testify to the formation of attachment relationships, and generally this mode of evidence, or the dispute of this mode of evidence about whether Erik's statements about what he felt about his parents or what his reasons were that he gave on cross examination for indicating that he loved his mother are consistent with what you would expect of children who develop with that kind of relationship with their parents. Mr. Khan says, yes, I asked the defendant a single question. I asked it several times, but it was a single question, and that question was, tell us what it is that you loved about your mother. That's the only question I asked him. Ms. Abramson says, you asked about attachment. You have a superficial attachment for your mother, Mr. Menendez, don't you? You asked. If I may finish, I asked that question several times, but it was all based upon the same single issue, that is, the feelings that he had toward his mother. And he said the only thing that he could think of that he loved about his mother was her smile. Now, counsel feels because of that one question, because of that one line of inquiry, that she can now put the victims on trial once again, as she did in the first trial, and she can now get in the experts through the back door. At most, what it does is it allows her to ask a couple of questions in rebuttal of the witness. If this witness did, if Kitty Menendez did not do anything positive for the defendant, and that is the reason why the witness cannot think of anything positive about his mother other than her smile, then that could be elicited through cross-examination of this witness. Which witness? Of this witness, Erik Menendez. The court says, you mean redirect examination? Mr. Khan says, in redirect examination, the question can be asked, did your mother do anything towards you to make you love her? And he can answer that question, and that should settle that matter. Ms. Abramson says, now he tells us what we can ask. One question. Yeah, I mean, it's not up to the prosecution to tell the defense how to do their case. Mr. Khan says, counsel can word the question however she wants to word the question. The issue before the court is, what does this open up? And the only thing it opens up is a clarification on the part of the defendant as to the answer that he gave. It doesn't open up the door to a slew of experts. Ms. Abramson says, I don't think I was talking about a slew, and I don't think counsel can dictate how many questions we can ask about our client about an issue that he got into, and here's how he got into it. It started with 44518, line 16, following a question about the rifle that Mrs. Menendez bought. Mr. Khan says, and that's because, and he said it with a sneer, I might add, and that's because it is the only way he talks to our client, and that's why you need a videotape, Mr. Khan, to capture your demeanor. And that's because you concluded that your mother loved you. Is that correct? Answer, I believe she did. Question, what made you believe that your mother loved you? Mr. Menendez. Answer, she was my mom. We loved each other. I could not imagine it being any other way. What was it about her as a person that caused you to conclude that she loved you? Mostly the fact that she was my mom. And I remember when she used to smile at me and how happy that would make me. And I felt throughout our childhood that I was trying to help her, and she would sometimes try to help me. I can't give you any specific reasons other than her smile. I just believed it. Question: was your relationship with your mother so superficial, Mr. Menendez, that when you think about your relationship, all you can think about is a smile on her face? And we objected, rephrased. Did you have a relationship with your mother, Mr. Menendez, that went any deeper than your appreciation of a nice smile on a face? You get the feeling, Your Honor. I mean, it's obvious he's being blamed for a mother who refused to attach to him, and we know from his previous testimony in the first trial that in every single aspect of her parenting, she accompanied it with anger, hostility, physical punishment, demeaning, spurning, and terrorizing, and I think we are entitled to prove that, not through our client, who cannot psychoanalyze himself or his own life, but through an expert to talk about why is it that he doesn't have more than reference to her smile to explain why he loves her given the way that she treated him. The court asks, why is this relevant? Really? Excuse me? Why is this relevant? The why of his beliefs. Ms. Abramson says, because the inference has been made that he is a defective and unfeeling person because he can only talk about, when talking about what it was about his mother that he loved, he can only conjure a smile. The fact is, the smile's all there was, and he didn't know. He didn't know her better as a person, as the prosecution asked, because of the way she treated him, because of the history of hers to withdraw affection and love and herself from him. And I can testify to that, and he can testify to that because he's not an expert. He can't testify to that because he's not an expert and we're not experts, but we believe an expert witness should be entitled to testify to what happens and what is it a child can call up when asked 25 years later on the witness stand, what can you tell us that's good about your mother? Why is it that you can't tell us more? And that is not a reflection on his lack of feeling or his lack of caring about his mother. It's that's what happens when you're raised by a parent who withholds affection, withholds nurturing, and gives you instead only negative and hostility and rejection. Court says, all right. My reaction is that perhaps that evidence would be admissible if it was a different trial and different issues were involved, but the issues in this case are issues relating to the mental state and motive. Abramson says, right, motive. The court says motive is not an element of the crime if it's been introduced. It's there, but the psychohistory of an individual and why he felt certain ways and your argument it was not his fault, none of those things are really relevant. Abramson says, well, why are you letting them ask these questions? Let me finish. None of these things are relevant to the issue of what the man's mental state was at the time he pulled the trigger. Ms. Abramson says, then why do you let the prosecution, over our objection, ask him questions about how he feels about his mother and what he relies on? The court says, was there an objection to that last question? Absolutely, says Ms. Abramson. Mr. Levin says every time. Ms. Abramson says, and you're letting them get away with these insinuations that our client is defective and heartless, and you won't let us prove that it was the mother who was defective and heartless. The court says again, you're going to why someone felt a certain way. Ms. Abramson says, we didn't ask the why, he asked it. You let him. The court says, you have to wait until I tell you what I think. The issue is what he thought, not why he thought. Ms. Abramson says, but you're letting him ask these why questions over our objection. The court says, this is what he thought, what his opinion was. What his opinion was, his state of mind, not the ways not the whys and the things of that nature. Ms. Abramson says, was your relationship with your mother so superficial? And the next question, did you have a relationship with your mother that went any deeper than your appreciation of a nice smile? Why is that relevant? The court says maybe it isn't, but I still don't see how that goes to what you're talking about, introducing evidence of. I think it is relevant, quite frankly, as to how he felt about the person he shot and killed. Miss Abramson says, right, right. Mr. 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 The court says, let me finish. It is relevant as to how he felt about the person he killed, but at the same time, the why of it, why he thought a certain way, reasons why, and whose fault it was, and those of the things of that nature are not relevant. Miss Abramson says, but it is relevant. Then let's jump to the more direct answer. What he thought about the person he killed depends on how that person treated him. Would you agree? As a basic postulate, if you dislike someone and then if you're asked, did you hate this person? Say you're a murder defendant, did you hate this person? Yes, I did. And we're not allowed to show why. It's the same thing. You only have a smile to show you loved your mother, and we're not allowed to show why he only. The court says you're showing it by his answer. He says that's what Miss Abramson says. It shouldn't have to depend on just his answer. It's not that he's spurning her. We should be able to show specifically how she treated him and why. Therefore, he can't come up with more than a smile. The court says, well, number one, you had quite a bit of evidence received before this jury, which you seem to have forgotten regarding the relationship of the defendant to each parent and specific instances of that relationship. You haven't gotten into anything. Not really, not yet. There's still a lot of people we haven't heard from yet, and a lot of incidents with their father that we haven't necessarily gone into completely. He says it's already before the jury. Miss Abramson says, but there's things you prohibited. The court says you ignore that. You talk about those things you didn't get in and ignore the things you did get in. Again, I don't see the relevance of this exploration of his upbringing and his childhood. Miss Abramson says it's very relevant to Dr. Wilson. We may have to fight this fight again. The court says we may very well. But as far as the request to have Dr. Hart testify about the psychological history of the defendant, his upbringing, and why it's the mother's fault he felt this way about her at the time he killed her, these things are irrelevant. How is his feelings towards his mother irrelevant? How is his relationship with his mother irrelevant? The things that were wrong with the relationship, how she treated him, how is that irrelevant? This is insane. See what I mean? It's everything's a battle now. Everything is going to be like this from now on until the end. It's incredibly frustrating for the poor Menendez brothers who didn't get a fair shake either trial, really. So these things are irrelevant to this trial, which is a focus on the mental state of the defendant at the time he pulled the trigger. But your mental state can be impacted on your childhood memories of your mother and how she treated you, can it not? I don't see how it's not relevant. Mr. Levin says, Your Honor, I respectfully disagree with the court. When Mr. Khan was asking these questions and I was objecting to the type of questions that went to motive, where Mr. Khan was trying to establish that there is nothing about the relationship between Erik Menendez and his mother that could possibly, in the mind of a reasonable juror, justify love. And what he was trying to show was leave in your mind the juror, knowing that we're going to be precluded from calling corroborative witnesses to many of these incidents to explain the full relationship that Erik Menendez had with his mother and father, to leave it to Erik Menendez to say, all I can tell you about a loving relationship is remembrance of her smile. And Mr. Khan is going to argue that there's absolutely no way in the mind of a reasonable person that if that's the only kind of remembrance that you have about your mother, to then turn around and say that you loved her. It's obvious that he must have hated her. And now on redirect, it It's going to be Mr. Menendez's obligation to try to explain in what fashion and how he possibly could have loved his mother given the types of memories that he had. And that's why I objected each and every time. And each and every time the court overruled these objections and allowed Mr. Menendez to testify to things and comments like Mr. Khan saying, "Can you tell this jury something about this woman as a person, not as a smiling face, but as a person?" I objected that that was vague. The court overruled it. And then Mr. Khan said, "You've just told this jury the full extent of your attachment to the woman. Is that correct?" Attachment is a crime, it is a word of art. It is a word that a psychologist such as Dr. Hart could explain based on the knowledge that has been gained and the expertise of the profession how it is, given the state of the attachment, if you will, that Erik Menendez had with his mother, that he could love her. It corroborates the fact that Erik Menendez, given the state of his upbringing, could in fact love his mother. Therefore, ergo, he doesn't hate her. And it's believable when he says, "I love my mother and I love my father." And I feel I've been severely hampered not only in the direct, but in the preclusion from the cross examination of bringing in this type of evidence. I couldn't bring it in on direct. Mr. Khan is allowed to bring it in, not in one question, a plethora of questions, hammering Mr. Menendez on attachment issues, on love issues, on smiling issues, ridiculing him, smiling. At one point, he laughed at his face, in his face. He laughed in his face. And now on redirect, am I going to be precluded from trying to have from having Erik Menendez testify like I should be able to, but the point that Erik Menendez loved his mother because that's what children do, and that's the kind of relationship that he had with her. And Stewart Hart can testify that in his expertise that that is real love, or that love is real. Sorry, whatever, same thing. The court says, okay, I don't see that this is relevant evidence to have in the trial. Seriously? I mean, goddamn. Miss Abramson and Mr. Levin fought hard for that. Mr. Gessler, too. What the hell? This is insane. Court says he doesn't see any relevance. What you're proposing here is expert evidence to establish the defendant's love. That's basically what you're saying. Miss Abramson says, not his, but that someone can love even a withholding mother. The court says, I don't see this as relevant evidence. Under Section 352 of the Evidence Code, its probative value is substantially outweighed by its potential for confusion. Mr. Levin says, we are then being denied our right to present evidence with respect to the defense of this case. I objected. There's nothing else that I can do. The court heard the answer. It's now heard counsel's arguments, not only with respect to the scope of the redirect, but with corroborative expert testimony that we have available and ready to present to this court to not only corroborate Erik Menendez, but refute the negative inferences that's been raised by the prosecution over the objection of the defense. And so I would ask then, and I'll cite to the court page, line and verse of that testimony that the court feels is relevant based on the argument I just made, that it be stricken from the record and the jury be admonished to disregard it. The court says, what I was talking about irrelevant is this offer that you're talking about of testimony of Dr. Hart. But if you want to cite me the questions and answers and the objections, I'll review it. Mr. Levin says, some of those sources appear on the following pages. The court says, why don't you just give it? You can just copy it for me and give it to me. Mr. Levin says, I can, Your Honor. The court says, and I'll look at the nature of your objections, if they were objections to the form of the questions or objections to the issues that you're now addressing. I don't recall this argument being made at that time. The issue that you're now arguing was one that was the basis for your objections, but if they were, then I'll certainly look at the record. Mr. Levin says, you can't argue an objection in the court. At least my feelings in the court is loath to have sidebars. So when I make an objection, I cite a legal basis, which I believe represents the argument that Court says, I'll look, as I said, I'll look at the objections. We've had sidebars and we've had articulation of objections, and as I recall, more than once even speaking objections. All right, what else then do you want to discuss today? We still have half a day. Nothing, says Miss Abramson. I don't want to talk to you anymore. We're not getting anywhere today. Court says, well, maybe we should keep going. Miss Abramson says, believe me, I've thought of everything. I can't think of anything else I want to talk to the court about today or tomorrow or Monday. Oh, God, I love her. I can't think of anything else I want to talk to the court about today or tomorrow or Monday. I need a 3-day break from you, Judge, because you have rattled my brain so much. I'm so angry at you. Oh, that's funny. That is funny. The court says, do the people have anything? Mr. Khan says, no, Your Honor. The court says, okay. Then we'll be in recess until Monday at 8:30. Ms. Abramson says, there is one thing. Were you serious? Was the court serious about role playing? The court says, about reading. Ms. Abramson says, if we decide to go with the transcript, I have to know about what my options are. If we decide to go with the transcripts, uh, would the court permit us to have Lyle Menendez role play with Lyle Menendez? I'm asking if you're serious. The court says, I kind of doubt if counsel for Lyle Menendez would agree to that. Ms. Abramson says, let's assume he does. Would you allow it? Court says, would the court and the jury also be instructed that he is unavailable as a witness to testify? Yes, he's unavailable to be called as a live witness, but he is available to read his previous testimony. The court says, and the reason for his unavailability? Because he's not being called to the witness stand by his lawyer. You want that? Why would it make any difference in any event if I went with the transcripts or went with video? Would the jury be told, I don't know if they should in any event? Well, that's an issue we can discuss, says the court. Ms. Abramson says, that's another issue. I want to know if you were serious about the role playing. The court says, obviously, in reading former testimony, it's not unusual to have the lawyers read and a witness to, or some other person to read the answers. I don't think it's appropriate to have the defendant do it. That was certainly made in jest, but certainly it wouldn't be appropriate to have parties or lawyers, not parties, lawyers or others read questions and answers. Ms. Abramson said no, the issue was to try to get the right demeanor evidence, and if we can't have the demeanor evidence in the videotape, I thought we might be able to have the demeanor evidence of Lyle Menendez reading it himself. The court says, I think the prosecution would then be entitled to cross examine on that demeanor in front of the jury if that was to be the case. All right, we'll be in recess until Monday. Yikes. Some heated arguments, man. Things are getting a little hot in that courtroom because Judge Weisberg doesn't want to budge. He doesn't want any of the abuse stuff coming in. He really doesn't want it. It has to come in through Erik, but he doesn't want it coming in through like anybody else, pretty much, it seems. And even expert witnesses, they should be able to call their own expert witness if they want to. And if it opened the door, and I think they made excellent arguments to say that it did open the door. And they fought really hard for that. And the judge is just like, nope, not gonna budge. So if you don't think that he's not a little, you know, pushing his hand down on the scale there, then I don't know what to tell you because it seems like every now and then he will throw the defense a bone. But for the most part, and as we've been reading this trial, I would say 95% of the objections are ruled in the prosecution's favor. And this is another one of them. So frustrating. Thank you guys for watching. Let me know what you think of this frustrating prosecution and apparently the judge also kind of Maybe they're in a conspiracy. How about that? I think they're in a conspiracy. Mr. Judge Stanley Weisberg and Mr. Khan are in a conspiracy to convict the Menendez brothers. They think that the lawyers for both sides are trying to try the case together or something in a conspiracy, which is ridiculous. I think they're in a conspiracy. Let me know if you agree in the comments below. I will see you guys in the next one. Thanks for watching. Take care. That's the end of this Trial Transcripts Exposed. Thanks for following along with me. Like if you want more, subscribe, and let me know what you think in the comments below. See you next time.